Testing, test. 1, 2, 3, 4, test. Testing, 1, 2, 3, 4, test. Test, 1, 2, 3, 4, test. Test. Testing. Test, 1, 2, 3, 4. Test. Test, test.
Good morning. The time is 8:30, and I'd like to call the November 7th, 2019 Enforcement Committee to order. Can we please take roll?
Nancy Springer has an excused absence. Frank Altamura,
Here.
Susan Granzella,
Here.
Mike Layton,
Here.
Diana Love.
Here.
Quorum is
We
established.
have a quorum. All right. Chair Nancy Springer has an excused absence. I am Mike Layton, an Enforcement Committee member who will take over in her absence today. And at this time, would Frank please lead us in the pledge?
Please stand. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, before we dive into the agenda items, I would like to take a moment to introduce one of our newest board members, Diana Love. Diana was appointed by Governor Gavin Newsom to represent California's senior consumers. Diana is a member and immediate past president of the Los Angeles County Commission for Older Adults, and additionally is very active in representing all the members of our community. Diana recently took part in the Solar Consumer Protection Government Task Force that was also attended by the representatives of the California Public Utility Commission and the Department of Business Oversight. The staff of the Contractor State License Board Valencia office are excited to have a board member nearby as Diana lives in Palmdale. Please join me in welcoming Diana Love to the Board of Enforcement Committee. Only board members who are members of the committee may sit at the table. All other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. Becky, can you please start by, well, we've already called roll and we've already established that we do have a quorum. Thank you. Next, I'd like to invite the committee members and staff to introduce themselves, and let's start to my right with Rick.
Hi, good morning. Rick Lopes, Chief of Public Affairs.
Missy Vickery, Chief of Enforcement.
Diana Love, board member.
Susan Granzella, board member.
Dave Foe, Registrar.
Mike Layton, board member.
Frank Altamura, board member.
Tanya Corcoran, Chief Deputy Registrar.
Christy Shilge, counsel for the board.
Becky Like, Enforcement.
All right, at this time, public comment for items not on the agenda and future agenda item requests. Seeing none. Next, we'll go into agenda item B, our public comment section. To allow the committee enough time to conduct its full schedule of business, I'll be limiting public comments to 3 minutes apiece. Please note that the state law prohibits committee members from discussing any matter brought up during public comment. We're also not allowed to act on any item not on the agenda. If you want the committee to discuss a topic not on the agenda, you can speak to us and consider placing it on an agenda for a future meeting. If you have an application, complaint, or disciplinary charges pending before the board, we ask that you do not discuss the details of the case or pending complaint. Committee members are not permitted to receive evidence or information that is not part of the administrative record in the case. Please be aware that this will not be that this will be the public's only opportunity to make comments during the meeting. If your comments are related to a specific agenda item, you can make your comments now, but you may want to wait until the item comes up for discussion. We'll be sure to ask for public comment before acting on each item. Any public comment at this time? Are there any members of the public who wish to address the committee or to offer an agenda item for a future meeting? Do any of the committee members have an item that they would like to place on a future meeting agenda? Well, I guess we'll move on to page 7, agenda item C. This item starts on page 9 of the packet with an update on the CSLB's disaster response and proactive enforcement in the disaster areas. In addition to the staffing of local assistance centers, LAC for the Sandalwood and Sandal Ridge fires, as reported in the packet, resources and staff have been dispatched to assist those who have been victimized by the Kincaid and Getty fires. Keep on. In mid-October, statewide investigative fraud team SWIFT conducted a sting operation in the Coffee Park disaster area in Santa Rosa with the assistance of the Sonoma County and Marin County District Attorney's offices. The two-day operation resulted in the issuance of 12 notices to appear in criminal court for unlicensed practices and 1 stop order for lack of workers' compensation insurance. I am now going to turn over to the Chief of Enforcement, Missy Vickers, to discuss internal policy and procedure changes to reduce expenditures and the general complaint handling statistics. Missy?
Thank you, Mike. Beginning on page 9, you'll find that enforcement has developed and implemented measures to reduce expenditures while not compromising consumer protection. I'd like to highlight some of those processes that we have implemented. We are taking a close look at vacant positions, but are optimistic that with the emergency fee increase that we'll be able to fill all vacant positions. We have also increased the use of the letter of admonishment. Between January and September 2019, we have issued 165 letters of admonishment and 119 fewer citations compared to the same time period last year. Issuing letters of admonishment allow us to resolve cases with informal conferences, office conferences, rather than a referral to the AG and a hearing before an administrative law judge. A letter of admonishment can include a corrective action plan, and if the corrective action plan requirements are not met, we can withdraw that letter of admonishment and issue a citation. Public disclosure of a letter of admonishment is 1 year. On page 10, you will see information pertaining to administrative citations. CSLB issues administrative citations for egregious violations of the law. On October 24th, CSLB staff met with AG leadership and the presiding law judge to discuss the need for higher civil penalties. This meeting has afforded us the opportunity to meet with judges statewide. We will be discussing the need to increase the maximum assessment of civil penalties during the next agenda item. In January 2019, CSLB received authorization to conduct informal citation conferences in order to resolve appealed citations. This process has proven very effective, and CSLB does not incur costs of the AG representation, and conferences can be scheduled more quickly than a formal appeal hearing. Moving on to complaint handling, which begins on page 10 of your packet, you will see that caseloads remain manageable. Complaint negotiation efforts by staff have successfully assisted in getting more than $18 million in restitution to injured parties. Staff have been consistent in continuing to achieve board goals and objectives of dispositioning an average of 10 complaints a month. Arbitration still proves to be an effective tool, with 638 cases initiated, resulting in $3 million in restitution. That concludes my update, Mike.
Is there any committee discussion on this item? Is there any public comment on this item? All right, hearing none, we'll go to section D, possible amendments to the Business and Professional Code, and you can follow along on page 13. Moving to agenda item D on page 13, review, discussion and possible actions to pursue legislation to amend Business and Professional Code under Section 7099.2. We will be discussing two issues for the committee's consideration. Issue number 1 involves civil penalty assessments, and issue number 2 involves letters of admonishment. Issue number 1 addresses the desire to increase the civil penalty assessments through threshold amount. Currently, Business and Professional Code 7099.2, Section B establishes $5,000 as the maximum civil penalty allowed for most violations of contractor's license law. Only violations of Business Professional Code 7114, aiding, abetting, and conspiring, and BPC, hiring an unlicensed contractor, allow for the maximum penalty of $15,000. Additionally, filing a false workers' compensation insurance exemption, a violation of the section 7125.4, has a maximum penalty of $5,000. The maximum cap on a civil penalty assessments was last increased in 2003, and the violation-specific cap was instituted in 1992, has never been adjusted to reflect the increases in California's Consumer Price Index, CPI. Since 1992, the California Consumer Price Index has increased 92%, and since 2003, it has increased 48%. Applying the respective CPI increases to existing caps would bring the general cap to $7,400 and the violation-specific amount to $28,800. The Business Professional Code Section 7125.4 makes it a cause for discipline for a contractor to have employees without providing workers' compensation. The maximum civil penalty of $5,000 does not reflect current economic conditions in the state's construction industry. This prospective C8 contractor, concrete contractor who has 10 full-time employees and a payroll of $500,000 would pay an estimated annual workers' comp insurance premium of from $28,000 to $40,000 per State Compensation Insurance Fund's website. For some licensees, the $5,000 civil penalty is a small price to pay in relationship to the actual cost of insurance for their employees. With rounding and some allowance for future CPI increases, staff proposes raising the general gap for civil penalties from $5,000 to $8,000, raising the violation-specific cap from $15,000 to $30,000, and including violations of Section 7125.4 as one of the violation-specific penalty assessments listed in the BPC Section 7099.2, subsection B, therefore raising the maximum penalty from $5,000 to $30,000. Is there any committee discussion on this item? Is there any public comment on this item? So at this time, we have a motion that I would like to ask for a motion that the Enforcement Committee recommend to the full board to pursue a legislative proposal to, 1, amend Business and Professional Code Section 7099.2, sub B, to increase the maximum civil penalty assessment specified from $5,000 to $8,000 and from $15,000 to $30,000 for violations of Business and Professionals Code 7114 and 7118, and number 2, add violations of Business and Professional Code 7125.4, filing false claim exemptions for workers' compensation insurance to the violation-specific penalty assessment listed in the statute. Is there a second?
Second.
We have a second. Is there any public comment on this item? Seeing none. Becky, would you take roll, please?
Nancy Springer has an excused absence. Frank Altamura,
Yes.
Susan Granzella. Mike Layton. Diana Love.
Aye.
Motion carries.
Thank you. Issue number 2, as it applies to the Business and Profession Code, Section 7099.2 addresses the inclusion of more than one violation of the contractor's state license law in a single letter of admonishment issues to a license. Currently, Business and Profession Code, Section 7099.2, subsection C6, precludes the use of a LOA if a multiple violations have been established to ensure that the LOA not be issued to rigorous offenders for whom a citation or citation or sessions would be more appropriate closing actions. However, many CSLB consumers complaint investigations establish multiple minor non-hazardous violations. An example of this is when a consumer files a complaint and the licensee agrees to settle any financial dispute. However, the licensee is out of name, style, and contact does not comply with home improvement contract requirements. These investigations might be appropriate for closure of a LOA, particularly one that includes a corrective action plan. The unintended consequences of the restriction are as follows. The field investigator who establishes multiple minor violations and elected to use the LOA can select only one of the violations for use in the LOA. Number 2, the additional violations will be disregarded and will not be captured in the CSLB's database, making them unavailable in future investigations into the same licensee. 3, additionally, the alternative to the LOA in the event of multiple violations would be the issuance of a citation for non-rigorous violations which have proven costly and result in delays in the resolution for the consumer and compliance by the contractor. Is there any committee discussion at this time? Are there any public comment at this time? Well, I'd ask for a motion. At this time, I would like for a motion pursue that the Enforcement Committee recommend that the full board approve that the full board pursue a legislative proposal to eliminate a multiple violation restriction for letters of acknowledgement in the Business and Professional Perfections Code, Section 7099-2, sub C. Is there a second?
Second.
Is there any public comment at this time?
So I just have a minor technical suggestion for the motion. Instead of saying approve the legislative proposal, that you authorize staff to pursue a legislative proposal, because it's not just approving the concept, but moving it forward to the legislature.
Thank you. I believe that's the way it was written, and I just did not read it properly.
Okay.
So if I may, at this time, I would like to ask for a motion that the Enforcement Committee recommend that the full board pursue a legislative proposed to eliminate the multi-violation restriction of letters of acknowledgement in the Business and Professional Code, Section 7099.2, sub C. It was all there rightly. I just could not read my own writing. So therefore, we do have a second. Yes. Is there any public comment? Seeing none, Becky, would you please take roll?
Yes, Nancy Springer, again, an excused absence. Frank Altamura.
Aye.
Susan Granzella.
Aye.
Mike Layton.
Aye.
Diana Love.
Aye.
Motion carries.
Thank you. All right. We're going to go to item E, On page 21, this is an update on the 2019 to 21 Enforcement Strategic Plan objectives. In reviewing the 2019 through 21 strategic plan that begins on page 23 of the packet, the Enforcement Division has been very successful in meeting the objectives set forth. I am now going to turn the discussion over to Missy Vickery for the strategic plan update. Missy, if you would, please.
Thank you, Mike. We previously discussed objectives 2.1 through 2.9, so today I'll brief you on items 2.7 and 2.9. For item 2.7, which is to provide training opportunities to improve morale and staff knowledge, on October 14th, Christy Schild of DCA's Legal Affairs Division presented specialized training to all supervisors and managers in CSLB's Enforcement Division. The training focused on the elements required for 3 violations of the Business and Professions Code. One was 7114, aiding and abetting an unlicensed contractor. 2 was 7118, hiring an unlicensed contractor. And 3 was 7117, acting as a contractor under unlicensed name or personnel. Thank you, Christy, for that. And next, for item 2.9, which is attend job fairs to promote employment opportunities at CSLB, I'd like to thank Becky Like for representing CSLB at a career fair at Sacramento State on September 30th and October 1st. Becky and another CSLB employee spoke with many individuals regarding CSLB employment opportunities, as well as explained the path to licensure to those that were interested in obtaining a license. So it was a twofold effort, and they were very successful. That concludes my update.
Thank you. Is there any committee discussion on this item? Are there any public comments on this item? Well, that concludes our agenda items. And at this time, can I have a motion to adjourn the Enforcement Committee?
So moved.
Second.
Becky?
Nancy Springer absent. Frank Altamura.
Yes.
Susan Granzella.
Yes.
Mike Layton.
Yes.
Diana Love.
Yes.
The Public Affairs Committee meeting will start in 10 minutes.
It's the simple things. Call to order the meeting for Public Affairs Program Update. Claire, would you call the roll?
Susan Granzella,
Here.
Frank Altamura,
Here.
Michael Layton, Diana Love.
Here.
Nancy Springer has an excused absence.
Thank you. Good morning. The time is 9:02. I call to order the November 7th, 2019 meeting of the Contractor State License Board Public Affairs Committee meeting. Only board members who are members of this committee may sit at the table. Other board members in attendance must observe from the audience. If a quorum of the board is present, those members observing cannot participate in the discussion. As noted before, Nancy Springer, a member of our committee, has an excused absence. I'd like to also welcome our newest committee member, Diana Love. Thank you for joining us.
Thank you.
We need accolades all the time. And I'd also like to mention something from our prior meeting. As we drove from our last board meeting in September, as we drove away from Chico, I had thanked you, Rick, for the organizing, the observing the conditions in Paradise, and that was an incredible education for all of us. But I forgot to thank you for an equally important act. What you did was setting up the meetings with the Paradise city members. They were, it was very informative, and I believe it benefited them as well. It was certainly good for us. So I have my comments, and Rick gave me a choice of doing the longer version or the shorter version. I think I'll do the longer version because it's a good story. And then Rick will fill in. It's no secret to committee members or anyone who has followed CSLB activities over the last few years that a lot of staff time and resources have been dedicated to supporting the survivors of natural disasters, particularly wildfires. I want to thank staff for their ongoing commitment to helping survivors get back on their feet. Rick will be able to elaborate on that a little more. Since our last meeting, CSLB, and as you know, there were more fires since our last meeting, has staffed 5 local assistance centers set up after the wildfires, 3 in Los Angeles County, 1 in Riverside, and 1 in Sonoma County. Thanks also to our public affairs staff to make sure those centers are properly stocked with outreach materials. I was mentioning this to Diana, what the procedure is for all of us to, put the materials in the van, take off, and see what you can do to help the public and the contractors. I want to be sure that the committee members understand that each disaster does not replace an earlier disaster as far as our work for staff. It adds to the workload. So in other words, as we work on one fire and the more fires come up, it increases the work for the staff. So I want to say thank you very much for their work on that. It's easy to forget just how many devastating wildfires there have been. Here's a partial list. This week marks the 1-year anniversary of the Camp Fire that destroyed almost 19,000 structures in Butte County, including much of the town of Paradise. In July 2018, the Carr Fire destroyed more than 1,600 structures in Redding and Shasta. And it's been 2 years now since a series of wildfires destroyed more than 7,500 structures in the North Bay, including parts of the city of Santa Rosa. That's also when the Thomas Fire roared, destroying more than 1,000 structures in Ventura and Santa Barbara counties, and 65 more the following month when a series of mud flows, and I think everyone will remember that, hit the Santa Barbara area. And over the last 4 years, at least 8 different major wildfires have roared through Lake County, destroying more than 1,800 structures. This is all in addition to the more than 100 lives that have been lost due to these fires. CSLB continues working in all various fire areas. Fortunately, the extensive outreach program that the staff undertakes after disasters has really helped minimize the number of consumer complaints. On a happier note, I can report that our new Public Affairs Digital Media Center is up and running. I'm told a few tweaks are still needed, but the new facility is being used for today's broadcast. This is a big deal. When I first came here, it was a room with boxes. And, excuse me, and then we had a meeting where we had the cameras that would roar around to whoever was speaking. So now this is all built in. It doesn't mean hours and hours of work on unpacking everything for the staff, and we're presuming this is working quite well. And is this the first webcast? Excellent. Well, that was a big deal, a long time coming, and congratulations to you and your staff for managing such an effort. Tours will be available after our meeting. All right, so the next item is, we'll start on page 33 of your meeting packet. Agenda item B. Agenda. Okay, so, public comment session for items not on agenda in page 33. Is that next on the agenda? All right. Next is agenda item B, which is for public comment and future agenda item request. So that would be, the committee values the public input on our consumer protection mission to allow us enough time to conduct our full schedule of business today. I'll be limiting public comments to 3 minutes. A few rules apply to public comment. First, California law prohibits committee members from discussing any matter brought up during public comment. Also, we're not allowed to act on any item not on today's agenda. Second, if you want the committee to discuss a topic not on the agenda, you can ask us to consider placing that issue on the agenda for a future meeting. Finally, if you have an application, complaint, or disciplinary charges pending before the board, we ask that you not discuss the details of your case or pending complaint. That's because the board members may be the judges and by law are not permitted to receive evidence or information that is not part of the administrative record in the case. This won't be the public's only opportunity to make comments during today's meeting. If your comments are regarding one of our agenda items, we'd encourage you to wait until we get to that item. You'll also have an opportunity to address us at that time. If your comments don't involve an agenda item, this is your opportunity to make them. With all this in mind, are there any members of the public who wish to address the committee or offer an agenda item for a future meeting? All right. Are there any members of the public who wish to address the committee? It's the same. Okay, it's the same. Isn't it the same message on the second bullet? Oh, well. And then, do any committee members have an item they'd like to place on the agenda for a future meeting? No? All right. Moving on. On the public affairs update, page 35 of the meeting packet. Next is the public affairs program update. For that, I'll turn it over to our public affairs chief, Rick Lopes. Thank you, Rick.
Thank you, Susan. Okay, we're going to start on page 37. As Susan mentioned, we do have the Digital Media Center, which is now up and running. And it is a dedicated studio and control room. So for our meetings that we have here in this room, you can hear we've got a built-in audio system and video system that we're able to use for our webcast. We will be still dragging cameras and cables when we go out on the road, but the process here in Sacramento is going to be much easier now. And what it's also going to do, which I'll talk to as we kind of go through our different reports this morning, it's going to enable us to expand the kinds of videos and webinars and training sessions that we're able to do and increase them not only for our employees, but also for licensees. And we'll talk about that as we go through. So you see some pictures there of the training that we went through, up and running, getting up and running with the equipment. We'd be happy to show anybody the room. It's kind of right behind me in the room adjoining this one. On page 38, I'll note briefly in the online highlights, we are making a particular focus on increasing our outreach to contractors, to licensees. Part of that is an expansion of our website content. We are in the process of creating a new blog-style site. We're working with our IT office right now to address some security issues that they have, but we're going to be expanding it, and you'll see that, and we'll be reporting in the weeks and months to come. But we have made a concerted effort to expand those materials. In the digital and video services, I'll note in the first thing, besides the board meeting that we did the streams for in Chico on September 24th, the week before that, we held a press conference in Parlier in Fresno County, and you can see pictures directly below that of a news conference. We did a Facebook Live of that. We also did, recordings of it. We had media coverage throughout Fresno County. It was a partnership with the Public Utilities Commission, the Department of Business Oversight, and the Fresno County DA's office. So we had a very successful media outreach addressing our solar consumer task force. That work continues. It's a great partnership. It included a mailing of a consumer guide to 300,000 PG&E users in Fresno County. And it was work that we did not only between the four partner agencies, we also had stakeholders and local groups that were involved in going through this. So it was a great partnership, probably 7 or 8 different groups all worked on this together, and so it was very successful. On page 39, in our social media, to note, especially for Diana, since this is her first meeting with us, we do have 7 different media channels in social media. Primarily the people that follow us and that we appeal to through those are industry as opposed to consumers. But you can see the numbers here. We started our first pages, our Facebook and Twitter and YouTube back in 2010, and you can see over the years that those have grown. I would draw your attention that we have started a second Twitter page, and we have a grand total of 8 followers right now. But this one's going to be focused solely on the media. It's going to have just press releases. We're not going to do anything besides that. So hopefully over time that'll grow with just media following us, knowing that we're not going to fill their screens with a bunch of information that doesn't apply to them. And you'll see as we go through the next couple of pages, as far as our different social media outlets, our Nextdoor partnership is something that was established a couple years ago after the fires. It is still limited. We are the second state agency to be able to have a partnership with Nextdoor after the Office of Emergency Services, and we're hoping to expand that beyond a limited number of counties. You can see on the top of page 40, we have currently in the network that we can reach is a little over 900,000 households. And then over the next few pages, I won't go through the details, but you can see some of the highlights on our Facebook and Twitter. We do put a lot of emphasis on this, and we have found that with the increased use of graphics and then with our new TV specialists, we're going to be increasing our video output, and we're seeing those really help our numbers of people engaging with the materials that we have and helping us spread that word. On page 43 in the email alerts, this is again something we've had going since 2010. We do have right now email addresses for a little bit over half of our licensees, 146,122. So the combination of that plus the people who've signed up to receive our various email alerts, we have email addresses for a little bit over 176,000 people or companies. On page 44, this takes a closer look at the email signups. I won't go through the chart there, but you can see by the different listings who has signed up to receive these, the numbers at least. And you'll notice too, the far right column, that number is steadily growing as our job openings. We do, as part of our promotion of getting jobs here at CSLB, we do send out a weekly email of current job openings, and that list has steadily grown over the last 3 years. In the media relations, consistently, we've had since August 35 different media inquiries. One of the ones I would just bring to the committee's attention as we talked about disasters, we were working with the Canadian Broadcast Corporation out of Toronto. They were doing a story on an unlicensed contractor who had some major problems doing disaster rebuilds in Canada and then came down to the Santa Rosa area. We currently have an investigation. We've done some local media on that, but the CBC was out and they did like a 9-minute piece, which for TV news is really long. It aired about a week and a half ago. So our investigation is near its conclusion, so we'll continue working with the CBC, but that was successful, and it did take some time, but that's gotten good coverage in Canada. As far as the press events I mentioned earlier, the publications and graphic designs, you can see that information there. I'll draw your attention on page 45 to the little graphic you see there. It's a sneak peek at the cover of our 2020 License Law and Reference book. We're in our final stages of approving the printed versions, and it should be out in January. As you go to page 45, down to the Southern California wildfire response, which is actually expanded because since this was printed, we've had the Kincaid fire, the major fire in Sonoma County that caused a lot of the PG&E planned power outages with the wind events we had. There is actually a local assistance center open up this week. Today, I believe, is the final day, so we are staffed there. And then the Getty fire, as was mentioned earlier. So 5 different local assistance centers over the last few weeks. And then, as Susan mentioned earlier, the campfire recovery meeting, there's the information that we did meet with folks in from the town of Paradise. You can see the 4 members there. We actually already have had follow-up calls. I had the housing program manager called me a few days ago, had a question about a nonprofit group that was coming in to help, and they had some questions, so we put them in touch with enforcement, and they were able to get their questions taken care of pretty quickly. As far as senior scam stoppers, the seniors are a particularly vulnerable group, and so we do focus a lot of our attention on outreach to the seniors. You can see on page 47, this is the list of senior scam stopper events that we've done for October, currently in November, and then also ahead through December. You can see we had 13 that we did in October, 13 this month, and then we've got 3 already on the calendar for next month. Things will slow down because of the holiday. You'll notice right below that the consumer scam stopper outreach, there's one actually going on today. Jane Kryler from our staff is down in Indio putting on a consumer scam stopper. And the final item is our CSLB bin, which is our intranet site, which is an internal site only for CSLB's 400 plus employees that we do maintain. And you've got a little bit of information on the stories that we present there. And with Halloween this past week, we've got photo shows and different things, but it's something that we do to be able to reach out and connect with our employees around the state. And that concludes our public affairs program update.
Thank you. Thank you, Rick. The next item is agenda item D, the review, discussion, and possible action to approve the 2022 CSLB Communications Plan. You'll find this on starting on page 49, 51 of your packet. Every 3 years, the Public Affairs Committee is asked to review and approve a communications plan that serves as the basis for the unit's strategic plan objectives. The plan also provides a framework for a wide variety of CSLB's internal and external communications for January 1st, 2020 to December 21st, 2022. To review the specifics of the plan, I again turn it over to Rick.
Thanks, Susan. Okay, we're just going to kind of briefly go through this. I'm sure you've had a chance to review it, so we'll just touch on some of the highlights that I want to be sure that you're aware of that we're addressing. And this is more of a 30,000-foot look at communications for the entire board for the next 3 years. Then when we get into our strategic plan, we focus in on a lot more specific action items. So this is kind of the bigger picture. So as we go through this, you'll see, I'll note on page 52, at the top, you see the CSLB mission statement, which is for the entire board. And during our strategic planning sessions, the board has an opportunity to review and that. So we're not looking to change that at all. In the public affairs mission statement, I will just note for you in the bullet points there, the first bullet point is, talks about one thing that's never going to go away is our purpose is to educate consumers, to make sure they can make informed choices. So that is at the beginning of everything we do. But I want to draw your attention to the 4th and 5th bullet points down. As I mentioned earlier, we are going to make an increased effort over the next couple of years at least to provide additional materials to both licensees and people that are interested or in the process of becoming licensed. So that is going to be a concerted effort that we are looking to make with the committee's support. Moving over on 53, you see the current list of staff and the key duties that they perform. Into page 54, in the target audiences, one of the things to note is we've got a whole variety of stakeholders in different audiences. And so that's one of the things that can make our job fun but challenging, is because there's lots of different groups to reach out to, more than we can ever do it at one time. But you see there everything from consumers to licensees to applicants to journey persons, unlicensed contractors, industry and trade groups, building departments, board members, elected officials, the prosecutorial agencies, the district attorneys, other industry groups, and CSLB employees. So there's lots of different groups to reach out to, and depending on what the topics are. On page 55, as far as our communications messages, you'll see it's reflected here, our increased focus on licensed contractors. And I would like to also, on the first area for licensed contractors, I would like to add one bullet point item. If you look at actually a little further down the page in the consumer section, you see that the very bottom one says call before you dig. It says it's critical that consumers and contractors. Since this message does go to contractors, I would like to add a bullet point that's going to have something about the call before you dig on the licensed contractor, in addition to having it advising the consumers. So you can see there that one of our main things we're going to be focusing on is our CSLB Toolbox, which will be our new outreach directly to the contractors I mentioned earlier on the website. We want them to be informed on the new laws, the importance of renewing their licenses on time, and then we'll add in the call before you dig. For the potential applicants and journey persons, we want to be able to discuss with them the benefits of becoming a licensed contractor, help explain to them and make sure they understand the steps it's going to take to become a licensed contractor and the legal risks of not getting a contractor's license. For the consumers, the new thing since the last communications plan is we do have our Find My License feature, so we are promoting that, and it's going to be one of the main areas that we're going to focus on. And I won't go through the entire list, but these are a lot of the main consumer outreach messages that we've had for a number of years. As far as the communication channels at the bottom of 55 and going on to 56, those haven't changed a lot. Obviously, there is the social media that has grown in importance. We are going to be looking to increase our video production now that we do have our TV specialist on staff. So not only videos, audios, podcasts, webinars, online courses, a whole series of things that we're looking to expand now that we've got our new facility in place as well. On 56 and 57, it addresses our goals, both short-term and long-term. Again, you see a lot of it focuses on the licenses and applicants. As we get into long-term goals, we want to maintain and update the license and applicant education materials. We want to expand online courses and some of the other things you see there. At the bottom of 57, in the tasks to measure our success, I'll quickly go through those. The timely completion of our strategic plan items, increasing the Find My License contractor searches, an increase in the website license checks. Well, actually, it's a long list. Maybe I won't read all of them, but you can see those there. And these are just ways. It's one of the things that can be difficult in public relations, public affairs, is to get measurements, especially when we talk about things like disasters. You never know how many consumers don't file a complaint because they did the work. So we look for the ways that we can find and increase our engagement, and increase people that are accessing materials, hoping that will then lead to them protecting themselves. So that is an overview of the communications plan, and we would appreciate having the committee's support.
So can you give us the specific language that you would like to add in for the bullet on call before you dig?
Sure. I'll probably, to make it very simple, we'll take the same language that is in that bottom for consumers. We'll use just the word contractors in the one above. It says, call before you dig. It's critical that contractors call 811 before doing outside projects that include digging to make sure you don't hit any underground utility lines. Then I would just say that maybe this bottom one will change that one to reflect just consumers. So the copy will be the same. The contractor one will say contractors. The consumer one will say consumers.
Very good, thank you. Is there any committee discussion on this item? Any public comment on this item? May I please have a motion to approve the CSLB 2020-2022 communications plan with the modification for the call before you dig to remove the contractor license, the contractor reference there. May I have a motion?
So moved.
Second? Thank you. Claire?
Susan Granzella,
Aye.
Frank Altamura,
Aye.
Michael Leighton, Diana Love,
Aye.
motion carries.
Thank you. Thank you.
Susan, can we call for public comment again?
Oh, call. Any committee discussion on this item? Any public comment on this item?
So just to refresh, before a motion, after a motion's made, you take public comment before you vote. So just a refresh recollection.
ma'am.
Okay,
Thank you. So now we are going to move on to item E, the update, discussion, and possible action to amend the 2019-2021 Public Affairs Strategic Plan objectives. The main items, we'll go ahead, and this is on page 59 of your packet, and we have the strategic plan followed on 61. So there are two changes we are proposing, and we can discuss the others as well. But we'd like to review the status. We're going to change the target date of 4.5 and 4.7 as noted in your packet. But before we go to that, item 4.1 was completed earlier this year. Item 4.2 is complete. As we noted at the June meeting, item 4.3 is no longer needed. Item 4.4 is well underway. 2 new suspects were added to our most wanted list, and both have been arrested. Item 4.5, the research has been completed. Staff is working with CSLB's IT unit and the Department of Consumer Affairs Information Security Office to address security and content management questions, which will delay implementation. Staff requested moving the implementation date from March 2020 to December 2020, and that will be part of the motion. So that is the strategic plan date that we will request a change. Item 4.6, there has been a lot of work done to create a new contractor website. As content is being gathered and created, our IT staff is working with the Department of Consumer Affairs to put a system in place to host the site and streamline the process needed to post materials online. The 4.7, staff met with board's IT committee, which consists of Frank Altamura and myself, and determined that IT priorities should shift to online renewals for existing licensees and then return to the online application. We were just shifting priorities as the business needs could be met in a more productive way. As a result, there is a request to move the target date on this item from December 2019 to July 2020. Item 4.8 is on track and assigned to our new videographer. Item 4.9 was moved up to focus on the ADA compliance. Reviewing and updating this website content is being done on an ongoing basis. And if I'm correct, the bulk of the work has been completed, correct?
Correct.
And it will be an ongoing basis. They'll be reviewing that because things do change quickly. Finally, on item 4.10, it's also being handled by our new videographer. May I please have a motion to amend the implementation for Public Affairs Strategic Plan 4.5 to December 2020 and to move the target date for Strategic Plan 4.7 to July 2020. All right,
Second.
very good. Is there any committee discussion on this item? Is there any public comment? Claire, can you please call the roll?
Sure. Susan Granzella,
Aye.
Frank Altamura,
Aye.
Michael Layton, Diana Love.
Aye.
Motion carries.
Thank you. All right. Our final item is adjournment. Can I please have a motion to adjourn the Public Affairs Committee meeting?
So motion.
Second.
Is there any committee discussion on this item? And any public discussion on this item? All right, Claire?
Susan Granzella,
Aye.
Frank Altamura,
Aye.
Michael Layton, Diana Love.
Aye.
You're done.
It does, all right. So the meeting is adjourned, there we go. And the next meeting, Legislative Committee meeting, starts at 10.
Yeah, be licensing at 10, immediately followed by the legislative committee.
Oh, I'm sorry.
Yeah.
Thank you.
Okay.
So they do a lot for public affairs.
Yes, they do.
Good morning. The time is 10 a.m. I call to order the November 7th, 2019 meeting of the Contractor States License Board's Licensing Committee. I'm David Diaz, the committee's chair. Only board members who are members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. Elizabeth Robinson, can you please call roll and establish a quorum?
David Diaz,
Here.
Kevin Albanese. Here. Augie Beltran.
Here.
David De La Torre.
Here.
Marlo Richardson absent. A quorum has been established.
Thank you. Next, I would like everyone at the table to introduce themselves. I'll start off with Mr. Rogers. Augie Beltran.
Augie Beltran, board member.
Tanya Corcoran, Chief Deputy Registrar.
Christy Shields, counsel for the board.
Elizabeth Robinson, License Management.
Justin Paddock, Licensing Chief.
Mike Jemnetsky, Legislation.
David De La Torre, board member.
Kevin Albanese, board member.
David Foat, registrar.
Thank you. And should we do the audience? No,
You don't have to. I mean, it's voluntary if they want to introduce themselves, but they're not required to.
Okay, then we'll just go. Sounds good to me. Next is agenda item B, our public comment section. This is the same thing we read every meeting. So if you've been here, you've heard it before. The committee values input from the public as part of its consumer protection mission and welcomes public comment on items not on today's agenda at this time. There are a few other rules that apply. First, California law prohibits committee members from discussing any matter brought up during public comment that is not on today's agenda. Also, we are not allowed to act on any item not on the agenda. If you want the committee to discuss a topic not on the agenda, you can ask us to consider placing that issue on the agenda in a future meeting. If you have if you have an application, complaint, or disciplinary charges pending before the board, we ask you that you not discuss the details of your case or pending complaint. That's because the board members may be the judges and by law are not permitted to receive evidence or information that is not part of the administrative record in this case. This will not be the public's only opportunity to comment during today's meeting. If your comments don't involve an item on the agenda, this is your opportunity to make them. If your comments are related to a specific agenda item, you may want to wait until the item comes up for discussion, or you can make your comments now if you prefer. To allow the committee sufficient time to conduct its scheduled business, we will be limiting public comment to 3 minutes per individual. At this time, are there any members of the public who wish to address the committee to offer an agenda item in a future meeting? Seeing none. Do any committee members have any item they would like to place on a future meeting agenda? No, I guess not. Okay, so hearing none, I guess we're going to move on to the next thing. Item C, licensing program update. Internal policy procedure changes related to the licensing applicant review. Recently, the executive office and the licensing division examined several policies and procedures the exam applicant unit and experience verification unit use in their day-to-day activities. After the review, several changes were put in place aimed at reducing processing times and reducing workload. These changes will provide added benefit to applicants. Justin will provide a brief summary on these changes. Justin?
Thank you so much. The executive office and the license management are essentially going unit by unit through the licensing division to see if there's ways that we can speed up the process, get rid of duplicative things, et cetera. The 2 units I'll be talking about today is just where we've started our effort. It's the exam applications unit and the experience verification unit. Just by way of background, the application examinations unit is typically where your application is going to go if you're a first-time contractor. So an original application, you're coming through the gate for the first time. Our experience verification unit actually occurs on the back end of the application process. So we bookended it. On the back end, after your application has posted, 3% of our cases are essentially pulled for audit to review, to make sure that their experience is correct. That's per statute. And for other internal purposes, for example, if there was an enforcement case in certain situations, those cases are also pulled to examine their experience. And our experience verification unit works with the applicant and whoever's certifying their experience to get further evidence to see if they meet the 4 years experience in the last 10, to either be a journey person, supervising employee, contractor, et cetera. So those are the two units that we started on. With the application exams unit, we found that we wanted to essentially implement a verification form so that we could return fewer applications. So whenever an application comes in where there's a minor issue, you wrote your business name down wrong, and it's a little bit different from what's actually registered on the Secretary of State's website. You may have inappropriately checked a box. What we do is we're going to have the individuals in our unit, they're doing it now, contact you if there's just 1 or 2 minor problems with your application, have a phone conversation with you, and during that phone conversation, fill out a verification form and take contemporaneous notes of what you've stated, and then we make those corrections on your application. Essentially, what this is trying to improve is instead of putting everything back in the mail and telling you to go fix it, if we've got just a few problems, we'd rather get you across the finish line. So we're hoping that this is going to reduce our rejection numbers that we'll be reporting to you quarterly, and we also hope, in a certain respect, that this is going to reduce our void numbers. Just quickly, I'll jump to the experience verification unit. There, what we're working on is there's a lot of situations where there's not a lot of paperwork for an employee. And that can be for various reasons that I'll let you just draw your own conclusions on. But certain employees, there's not a lot of paperwork to prove up. This guy worked for me for the last 6 years. He's he knows what he's doing. He's a journeyman. He's fine. In those situations, if there's no issue with the licensee, so that licensee who's certifying the experience has been in good standing, we're actually going to have them fill out an affidavit of sorts, and we're going to rely upon that in many instances. So that's a brief summary of what we're doing. We're going to keep going through our units to see if there's other opportunities where we can sort of minimize rejection when possible without actually doing good analysis on the applicant. Happy to answer any questions.
This is an informational item, so we don't need to take any action. Do committee members have any comments? Seeing none. Is there any public comment on this item? Seeing none. Item D, update and discussion regarding cost-benefit analysis to outsource Cslb exam administration. Committee members, if you turn to page 77, I will briefly discuss staff's recent efforts to finalize a cost-benefit analysis for outsourcing CSLB's exam administration unit. You may recall at our last meeting, we authorized staff to postpone finalizing their cost-benefit analysis report until the December meeting, because of the Department of Consumer Affairs was negotiating new items with their exam administrator, PSI exams. As DCA's exam proctor, we need to know what PSI exam costs are so they can compare to the CSLB's examination costs. We anticipate having sufficient cost comparison data for staff to make a recommendation to the full board at the December 12 meeting. I'll ask Justin to briefly summarize what the staff recently done and what we can expect in December. Justin?
I'll be very brief. We've met with PSI exams. We've met with DCA staff. We're certainly very close. We're going to be finalizing our numbers, and we feel that we'll have a good projection for you come December 12th for the meeting. And we'll also have a staff recommendation as well. Happy to answer any questions.
Again, this was an informational item. Do we have any board members with questions or comments? Anybody from the public, questions or comments? Okay. Let's see. Item E, review and discussion of potential need to amend the scope of hazardous substance removal certification. Committee members, please turn to page 81. In implementing strategic plan licensing item 1.2, to review licensing classification determinations for consistency, staff identified an issue with hazardous substance removal certification. Justin, will you provide a briefing on the matter and identify the next steps, please?
Certainly. Just by way of background, if you're going to perform hazardous removal work in the state of California, you would as a contractor, which would be the removal, or if you're going to remove or install an underground storage tank, you need this hazardous certification from us. Laws surrounding that certification really haven't substantively changed since about 1993. So as we were going through with our strategic plan objective, we just identified some issues, and this one's ready to get some updates. Based on that, I'll give you just a couple very brief examples. Remediation by law, the way the law is actually written requires you to dig into the earth. There's a lot of remediation work where that's not necessarily the case. You could be remediating something in an existing building. There could be a water issue. There could even be an air issue for some of our contractors. That will certainly need to be updated. In addition to that, by way of how our regulation works at the moment, C21s who actually are doing removal can't get the certification. So I think we need to also look at that. With that, I think David had a few comments with regards to some information he's received from industry.
Yes, thank you, Justin. I've received a number of calls from industry leaders regarding the wildfire debris removal and the concerns that they have. And the concerns are that we have contractors performing this debris removal, digging into the earth, and there is no requirement that they be certified, and that this material contains asbestos, toxins, chemicals, lots of different reasons why it would be helpful to have the certification apply to these projects. As it stands today, there's no certification requirement unless they're removing underground storage tanks or the project is listed by the Department of Toxic Substance Control, or it's a Superfund site. So what I've told them, appreciate this being on the agenda for consideration, and we'll take a look at it and see if the statute would need to be amended to provide for a requirement that in certain situations that a certification would be necessary to protect the worker and the public. Thank you.
So just to wrap up the item, the purpose of bringing it to the committee today is to just let the committee know staff has identified a serious issue that needs to be addressed. This is going to be a bit of a sticky issue. We're going to have to work with a lot of our sister state agencies, which I plan to start momentarily in the coming weeks. That's going to be Department of Industrial Relations, Department of Toxic Substances Control, State Water Resources Control Board. It will take some effort, but I just wanted to make committee aware. Happy to answer any questions.
Okay, is there any questions from the board?
Yeah, Mr. Chairman,
Yeah.
more of a comment. I'm fully in support of a highly trained, highly qualified workforce, especially when it comes to handling contaminants. I guess my question would be, what would be the definition of demolition? Because sometimes it's in concert. We do, demolitions in concert with abatement or remediation. So I think we need to identify what demolition is.
If I may, at the moment, that's a bit of a gray area. And you've highlighted one question, and I think between Mike and I, we've got quite a few, and that's certainly near the top of the list. Again, especially when you're getting to an individual project and you look at that specific project and look at our law, it's incredibly tricky. I can't give you a straightforward answer on any given project, which is why I think this is just well past overdue.
Thank you.
Any other comments from the board? Any comments from the public? Okay, moving on to the next item. Item F, review and discussion regarding feasibility of creating a CSLB license applicant satisfaction, I guess is the right word, survey. Okay. Committee members, please turn to page 85. As many of you are aware, CSLB surveys individuals who file a complaint with the board after the complaint process is concluded. During our last board meeting in Chico, a question was asked about whether any such survey is done with licensed applicants, which it's not. Based on that comment, staff put together a concept for an applicant survey that could be completed by the applicants on the internet via a link sent to their email. Staff prepared several potential questions that would appreciate any comments and additions from the committee. I guess there's 8 or 10 of them on there. Do the committee members have any comments? No, seeing none. Does the public have any comments? Would anybody on the committee make a motion? For example, the committee could move to direct staff to present the survey to the full board for consideration and adoption.
So moved.
Do you have a second?
Second.
Okay, does the board members have any comments on the motion? Okay, does the public have any comments on the motion? Seeing none, Elizabeth, can you take roll?
David Diaz.
Yes.
Kevin Albanese.
Yes.
Augie Beltran.
Aye.
David De La Torre.
Aye.
Marlo Richardson absent. Motion passes.
Thank you. Okay. All right. Item G, update, discussion, and possible action to amend the 2019 to 2021 licensing and testing strategic plan updates. Next, agenda item G, a review and discuss, I just said that. Can you see the update, or you can see the updates on 89 in your meeting packet. Justin, can you give an update on item 1.7 related to developing online contractors license application?
Certainly. And actually what I'll first say is on item 1.12, there's actually an error on the update, so I apologize to the committee. That work that I remarked has not yet begun. It's actually ongoing. We're already doing surveys and reaching out to agencies and associations. So my apologies for that inadvertent miscommunication. Moving to item 1.7, based on discussions that we've had with the board and this committee, we're just shifting priorities. Our first focus is going to be the online renewal for sole owners. Our project rollout date for that is going to be February of next year. Because of that, the fact that we're shifting priorities, we're just moving the applicants to right after we finish that effort. So all we're asking for is that we move the deadline for the applicant going online to July of 2020, which is our targeted date. Happy to answer any questions.
Do any board members have any questions or comments? Is there any public comment? Seeing none. Can I get a motion and a second?
Second.
Recommend that the board amend the licensing 2019 to 2021 strategic plan objective 1.7 target date to July 2020.
So moved. Second.
Thank you. Any board members have any comments? Does the public have any comment? Elizabeth, can you take roll, please?
David Diaz.
Yes.
Kevin Albanese.
Yes.
Augie Beltran.
Aye.
David De La Torre.
Aye.
Marlo Richardson absent. Motion passes.
Okay, that's all the committee's business for the day. Can I get a motion and a second to adjourn the meeting?
So moved.
Second.
Okay, any public comment on that one? No? Elizabeth, can you take roll?
David Diaz.
Yes.
Kevin Albanese.
Yes.
Augie Beltran.
Aye.
David De La Torre.
Aye.
Marlo Richardson absent. Passes.
Okay, we are adjourned.
Next meeting will start in 5 minutes. We now call the November 7th, 2019 Legislative Committee meeting to order of the Contractor State License Board. I'm Augie Beltran. I am the committee chair. Only board members of the committee may sit at the table. Other board members who are in attendance must observe from the audience. If a quorum of the board is present, those members who are observing cannot participate in the discussion. Feliz, please take roll.
Augie Beltran. Kevin Albanese. David De La Torre.
Here.
Dave Diaz. Marlo Richardson has an excused absence. We have a quorum.
Thank you. So we start out with item B, public comment for items not on the agenda and future agenda item requests. This item is provided for the public pertaining to items on the agenda. Please remember the committee cannot discuss or take any action on items not listed on the agenda. The CSLB welcomes public comment on any item on the agenda. It's a CSLB's intent to ask for public comment prior to the committee taking action on any agenda item. But if for some reason we forget to ask for public comment on the agenda item, a member of the public desiring to comment on this item should raise their hand and they will be recognized. Also, to allow this committee sufficient time to conduct its scheduled business, we will be limiting public comment to 3 minutes per individual. Chief Jay, you're the timekeeper today. Are there any comments from the committee at this time? Any comments from the public at this time? We move on to agenda item C, review, discussion, and possible action to replace copies of legislative bill text with a reference to a website link in future legislative committee and board packets. Chief, what do you got?
Yeah, there are two reasons why this item is here. Number one, in September at the meeting of the board in Chico, members did discuss some ways to save money, and one of them was to reduce paper and the cost of mailing packets. But number two, when we include bill text in a packet, it's really just a snapshot in time. The text that's actually in the packet of the bill doesn't reflect what has occurred to the bill in the previous weeks, and often will not be the latest text because of the time period between publishing a packet and actually getting it before the board. For those reasons, and because it's the digital age, we're going to suggest that we include a website link to the bill text rather than stick hundreds of pages in the packet each meeting.
Any comments from the public? Any comments from the board? Are you going to put a QR code on that?
We'll talk to our IT division.
Okay. Yep.
So I just want to make sure it's clear that you will no longer have bill text in your packets, so it'll be incumbent upon the board members to look up the bills online and read them. So just be aware of that, that will be a workload issue for you to manage in order to be prepared for the meetings.
Just email us the bills so we have it in our possession, right? So we don't
Yes.
have to look them up?
Yes, and staff will do its due diligence to produce analysis and summaries.
Right, and the QR code will take you straight to the page. Any other public comment? There was none, but there could be some now. Anything from the board? Nothing. Good. So the chair would accept a motion to replace copies of legislative bill text with the reference to a website link in future legislative committee and board packets.
So moved.
Have a motion, a second. Once again, public, any questions? Board, any questions? Feliz, take roll, please.
Augie Beltran.
Aye.
Kevin Albanese. David De La Torre.
Aye.
Dave Diaz.
Yes.
Motion passes.
Item D, review, discussion, and possible action to pursue legislation to amend Business and Professions Code Section 7067.6 to authorize a registrar to accept a license renewal with the signature of a qualifier only. This legislative proposal begins on page 105 of your packet. It would modify the signature requirement for all license renewals to allow any licensed qualifier to sign a renewal on behalf of a licensed entity. Chief.
Yes. So speaking of the digital age, currently our renewals do require a wet signature. Not only that, the statute requires both the applicant for the renewal and a qualifying individual to sign it. So depending on the structure of a corporation, you would oftentimes require many signatures. That is ultimately a reason a lot of renewals are rejected and licensees are expired even when the renewal is timely because of problems with signatures. It seems reasonable to require one signature, and that would be the qualifier, the person responsible for construction operations, and do that maybe electronically as well.
So I don't know if you want to discuss the legislative proposals, and the text is on page 106, but I did have some questions about the strikeout on the second paragraph.
Yes, on page 106, you'll see the addition to the existing statute. The blue language is the addition, and the red was the proposed strike-through. Upon discussion with council, we're actually, the language as we present it to the board, if this proposal does vote through at this meeting, will not include that red strike-through, and that's because at the time when we struck this, we thought that it would be reasonable to not require the board to go through the regulatory process to get this signature requirement through. However, there are some legal requirements imposed by the Secretary of State that would actually make it more onerous for licensees if the board does not come up with its own process and regulation for dealing with the electronic signatures. So in other words, we got ahead of ourselves by striking this existing paragraph. We'll probably put it back in when we next introduce this proposal.
So just for real quick background, the proposal really is just to change the signature requirement. Staff also thought we would maybe delete the second paragraph that allowed you to develop regulations for electronic transmission of applications, including signatures. So under California State Law, Government Code Section 16.5, public entities are only allowed to accept a digital signature that meet the requirements of the Secretary of State's regulations, and they're very extensive. So years ago, our office recommended this language that's being struck so that you could come up with an alternative proposal that might be simpler and easier than the Secretary of State's regulations. And so I wouldn't recommend striking this paragraph because it would eliminate your flexibility and discretion to come up with a simpler option for electronic transmission of applications, including digital signatures. So I would suggest not doing this strike through in the second paragraph. I have no concerns with the rest of the proposal.
So as I understand it, if I remember right, any member that's listed on the license and all qualifiers have to sign it. And this is asking that only one qualifier has to sign. What if there's multiple qualifiers for different classifications?
The way that it's written now, it would be any person qualifying, so it would be any one of those qualifiers.
Yeah, I think I would have a problem with that, because if you have multiple qualifiers, so say you got a qualifier for the C8 and then one for the C50, I mean, just throwing stuff out. If they're not active enough in the business to sign an application every 2 years, then they probably shouldn't be on the license, I think. How big is this problem where these are being rejected?
Mike, if I could, I think one of the reasons why we're presenting this is because we want to provide for online renewals. As it is today, we have to have a paper copy with a check. And so this would allow us to accept it electronically with using a credit card. Tanya, you want to add to that? Because you've been taking the lead on this.
Yeah, so from an IT perspective, it's very difficult to do a transaction online where you have multiple signatures, because you have to actually pin to the renewal, then it has to know where to send it to next. And so this would provide for us an easy way for us to go online and go online quickly with having a one signature requirement.
Kevin, you got more on that?
No, I'm just, I understand for that aspect, for the online aspect a bit. I'm just concerned because, you know, there is personal liability to the contractor, to the qualifier, that he or she is actively involved, monitoring the business, et cetera. And, you know, at least every 2 years, they're reaffirming their obligation to do that. And I don't want to lose that. And I just probably need to wrap my mind around it a little bit more, should this go to the full board. But I do have some concerns just about how that, and we've talked about RMO agency, we've talked about these rental, deals where, they don't even know what there's going on in the business. And to give them an excuse or an opportunity for somebody else within the business to sign that on their behalf causes me some concern.
Thank you. David Diaz.
Yeah, I understand Kevin's concerns. Do we really need this right now, or do you want to vet it more, or I'm kind of asking you, Kevin.
I'm willing, I would say study it a little bit more. I mean, at the risk of getting paralysis by analysis. I think there needs to be more of a cost benefit to, okay, I mean, if we can go online, next month or next year, and this is what needs to happen, then maybe that outweighs the other. But in as much as we still need to do the online stuff and figure that out, I feel like we'd be rushing this at this point.
Tanya?
Yes, so we are looking at the online renewal for sole owners, and we'll be able to be online for that because that requires the one signature. So what it will result is a delay moving the others with multiple signatures going forward, but not a problem to study it more and provide more data.
Anyone on this side of the dais? Anything else? Public, do you have any comments on this? It sounds like the committee wants to send it back to study. Can we bring it back to the next Ledge Committee?
Absolutely.
Unless there's somebody out there who wants to make a motion. David, did you want to say something? No, you're good? Okay. So we're going to leave it to the next, let's study it a little bit more. That keeps it timely, right? Okay. Is this something that we have to hurry up to get in front of the legislature or anything?
I don't think, we have plenty of ledge proposals pending.
Okay,
Yeah.
good. All right. E, review, discussion, and possible action to pursue legislation to amend Business and Professions Code Section 7071.19 to provide 45 days notice period prior to suspending the license and address retroactive policy renewals. We are now on page 109 of your packet. We were pleased to learn subsequent to this posting of this agenda item that staff implemented a process whereby insurance companies may submit limited liability insurance policies electronically. It appears this process may have resolved the need for legislation. As such, we are recommending that no action be taken on this item to provide time to determine the success of the electronic filing process. Chief, you have anything to add?
Just that this is really here because in 2018, the board approved this concept in the sunset review. But like we said, we've implemented some changes. There's only 3,500 LLCs, and more than half of them submitted their certificates online. So we think we nipped this problem in the bud. Why change the law?
Counselor? Nothing? Wow. Anyone on this side of the dais have anything to say about this matter? No? Public, anything to say? Okay, tabled. In closing, we'd like to direct staff to update the committee on the success of the electronic filing process at a future legislative committee meeting. Thank you. Good job, staff. F, review, discussion, and possible action to pursue legislation to amend Business and Professions Code Section 7076.2 to increase from 30 days to 60 days for licensee to provide proof of proper registration and good standing with the Secretary of State prior to license suspension. This legislative proposal begins on page 113 of your packet. It would modify the law to provide 60 days instead of 30 for a licensee to comply with the Secretary of State requirements before the CSLB automatically suspends a license for issues with the Secretary of State standing. The board approved the concept for this proposal on September 2018 as part of the sunset review process. What do you got, Chief?
Just that this has been, it's another one of the reasons that licenses get held up. If you look on the bottom of page 113 of your packet, there's any number of issues an entity can have with Secretary of State that causes a delay, and we have found that it takes more than 30 days for those items to be resolved. But the main the main compelling aspect of this was that the Secretary of State itself provides entities 60 days to resolve certain issues with their statements of information. So we figured we would match that date and make it easier for licensees to get back into business without a suspension.
Counselor? It's twice. Good job. Anyone on this side of the dais? No. Public comment? Nothing. Okay. So the chair would entertain a motion to recommend to the full board pursue this legislative proposal to modify the law to provide 60 days instead of 30 days for a licensee to comply with the Secretary of State requirements before CSLB automatically suspends a license.
So moved.
Second.
We have a motion and a second. On the question from this side of the dais, no questions. Public questions? Nope. Good. Thank you. Feliz.
Lucky Beltran.
Aye.
Kevin Albanese.
Aye.
David Elatorre.
Aye.
Dave Diaz.
Aye.
Motion passes.
Thank you. Item G, update, discussion, and possible action to amend 2019-2021 Legislative Strategic Plan Objectives. We are now on page 117. Chief, hit it.
So the highlights on pages 117 and 118 are actually typos. The board actually in Chico did already vote to amend the dates that needed to be pushed back. So I don't have any updates on this item if there's no questions.
Sweet. Counselor? That's 3. Anyone on this side of the dais? Public? Nothing. Thank you. We now move on to item H. Review, discussion, and possible action to rescind the motion adopted at the August 6, 2019 Legislative Committee meeting relating to staff study and preparation of regulatory language to permit the C46 solar contractor classification to install battery energy storage systems, ESS, on specified residential units with restrictions. This is going to be a long script, so bear with us. This brings us to the issue of energy storage systems. There is no content in the packet for this agenda item or the next agenda item. For background, at the direction of the board, staff has been researching the appropriate classification to install a battery energy storage system since early 2018. In March 2019, staff published for the board an 81-page ESS report and distributed and received hours of public testimony on the proper classification to install ESS. It should be emphasized that staff has done a lot of work on this subject, from research to studies to reports to conducting interviews and holding informal hearings and industry meetings. Staff has done a bang-up job. They've done all the research. They've had the hearings. They've done an awesome job, and thank you to staff for all of your efforts and legal expertise. In addition to the hundreds of written letters staff received and reviewed, CSLB heard and received over 300 incidents of individual testimony provided from either side of the C46 or C10 industry in a variety of public forums since early 2018. At the back of the room, staff has provided a timeline detailing at least half a dozen industry meetings held on the matter, half of which were joint meetings, and like I said, it's the back of the table. Staff has worked very closely with both sides of this issue to ensure we get the right response. As you know, at the August 6th meeting of this committee, we heard hours of testimony from over 80 people, including testimony from invited experts on all sides of the issue. On the topic of proper classification to install energy storage systems, this committee passed out the following motion. But before that, once again, staff has worked very diligently to try and resolve this and help us come down with the decision. The C10s had an expert, C46s provided an expert, and the building officials provided an expert, and we took that testimony down as well. Keep in mind, all of this testimony has been recorded electronically. The committee passed the following motion on that date of August 6. The motion was recommend directing staff to prepare regulatory language to permit C46 solar contractor classification to install battery energy storage systems, ESS, on specified residential units with restrictions, with the further recommendation that staff study ESS size, complexity, voltage, and risk, and bring that information back to this committee. After the August 6th meeting, staff held subsequent meetings with industry, and alongside staff, I myself personally met with the Department of Consumer Affairs Executive Office and their legal counsel, who provided their insights and recommendations. Following these meetings and discussion with our own counsel, we've given this issue further consideration. We are now recommending that the committee consider recommending to the full board that the staff hire 1 or 2 consultants to review this issue. We are making this recommendation because after numerous public meetings that afforded the opportunity for more than 300 people to testify, it is evident to us that the CSLB should conduct further study on this issue. With regard to economic issues, both industries have submitted economic impact reports that are available at the back table, or if additional copies are needed upon request, we can make that happen. The solar industry report states that the economic impact on restricting C46 classification from installing commercial battery systems may be 90 million or more. The economic impact report received from the electrical industry indicates there will be no economic impact. With regard to numerous public safety issues, numerous solar industry representatives have testified that the battery installation is routine and does not pose a safety threat. On the other hand, the electrical industry representatives have testified battery installation requires electrical knowledge and that the electrician certification training requirement is vital to protecting public safety. We've heard you. We've heard both sides of you. As much as we appreciate staff's study and efforts to achieve a resolution to this matter over the months, we believe that an outside consultant will be helpful in reviewing all the information received and/or any need for possible additional information in a report that will result in an independent analysis before board consideration of these issues. This is in order to allow the board to make a sound and fair decision. We believe it's the best course of action that an independent third party or parties research the issue and come back with the recommendation for board consideration. Independent, neutral, third party. As a reminder, Government Code Section 11349 requires the record of any potential rulemaking by an agency to demonstrate by substantial evidence the need for any proposed changes to regulations. This would include any proposed changes to existing C46 contractor classification or any other classifications. According to this legal standard, evidence includes, but is not limited to, facts, studies, and expert opinion. If this committee recommends to the full board the hiring of an independent expert or consultant and the associated expense of doing so, the board will need to provide final approval. Based on the foregoing, we are recommending that the legislative committee action from August 6, 2019 not go forward to the CSLB, so that the CSLB may further study this issue. And 2 new motions be made. 1, to rescind the original motion. And the second, to secure approval to seek a qualified expert or experts to assist the CSLB in its study of issues and information received on battery energy storage system installation. With that, I think I've been pretty clear, but I'm sure there are people that are not clear. So we're going to ask the public for any comments on what I just said. Are there any public comments on what was just said? Board, behind the dais, is there any comments on what was just said?
Oops, sorry.
Counselor? No? Chief? David, you want to say something?
Yeah, it seems how it was my motion, I believe, in August. I know we've been discussing this thing, seems like almost since I've been on the board, and which has been like 8 or 9, 10 years, whatever it is now. I want to make sure that if we're going to do this, and the expert or experts, well, one thing you said in there was expert opinion. I don't want any opinion, I want facts. Honestly, an opinion to me isn't a fact. In fact, I have a shirt that says that. Anyhow, I want to make sure that they, I wrote a bunch of stuff down here. We're going to prepare a report for the risk, size, type, and occupancy of a ESS storage system or energy storage system. That is not, to see if it's no longer incidental to a PV system, and it could be outside the scope of a C46 license or whatever. And a lot of this stuff clicked in my head even more so when my neighbor just recently had a PV systems installed on his house by PG&E, and I asked the guys why they're wearing 3 different shirts, and they go, because we're all independent contractors that we all work for this 3 different companies. And then I go, well, you guys certified electricians? No, but they tied into the panel. So we got to look into this stuff and really make sure what's going on. I get home from, like I said, I get home from work and I see this going on in the neighbor's house, and there's a lot more issues just besides that. I think, again, I want the report to have evidence supporting all the thresholds or whatever we want to put on it, based on technology and supporting documents, maybe established by national and state standards. I also sit on a bunch of code committees through the state of California and national code committees, so I know how important that is for national and state standards and codes. Do an economic impact. This is just notes, impact analysis notes I wrote down for thresholds based on verifiable information, not speculation. To direct staff to identify and retain outside expert, that's what we're talking about here. To prepare a report, threshold and regulation, I can't even read my own writing sometimes. And to thresholds and regulations, and then bring it back to the committee or to the board for board consideration. I mean, basically what I'm really wanting, I mean, I know that there's issues on both sides, and we have, I guess, these papers on both sides, but they came today or whatever, we didn't have time to read them. But again, I don't want hearsay or anything, opinion. I want facts and data to support all this, and that's what we really need, not, like I said, hearsay. I was at PG&E, I don't know, about 4 months ago, and they were talking about training, and this was on the HVAC side, which that's my field of expertise. And the guy at PG&E says, well, if you have a contractor license, that means you're trained. And I go, well, I used to work for a company that had 1,500 employees with a sole owner. He's the one who took the test for the contractor's license. It didn't say anything about training any individuals. So training is huge. I know C10 contractors have to have certified electricians, which I believe in, because there's a lot of issues with contractors' licenses. I mean, not contractors, like with electricians or non-electricians hooking up a lot of different things. So, you know, I just want to see the facts and everything lined up and make sure that, I know staff has always done a great job with this stuff, and I guess now that we want to do something else with staff to make sure, I don't even know if this is actually a legislative issue or a licensing issue, whatever it is, to make sure that it's done and laid out, and then hopefully we'll be done with this.
Thank you. Anything else from the board? Yeah.
Yeah, I think this is probably the right way to go. I mean, there's been a lot of confusion, even on the motion. You know, I mean, when we talked about it at the meeting and prior to voting, I expressed some concern about just the residential, limiting it to residential. Like, that should be part of the study so that we understand whether it's occupancy, maybe that's a better threshold versus residential, what have you. And we've heard all the arguments on both sides, and they're all arguments. It really, I think Dave's right. We need to get down to that substantial evidence. The likelihood of this thing going to litigation, whatever is done, is, I think, pretty high. And so we better have facts, not hyperbole, you know, documented instances or issues that is a harm that we're actually trying to solve for the consumer. And whatever that looks like, whatever those thresholds are, that we have that evidentiary support. And I think staff, as much of a great job and as laudable as they've been, it's just such a thorny issue that we need that independent, almost like an arbiter, to cut through, figure out what the facts are, present those facts to the board, for the board to make a good decision. So I agree with what Dave said. I agree with Augie, and when the appropriate times come, I'd be happy to make that motion.
Anything else from the side of the dais?
Yeah, can we have, maybe if we do this, to have maybe two board members work with the staff? And when it all comes up?
So this motion is just, this article, this part of it
We haven't made any motion.
is just about rescinding the motion. So on the next one, if it is rescinded, the next one is to discuss directing staff. That would be appropriate to mention at that point.
Okay, all right.
Okay. Public comments closed, but I'll open it up again. Go ahead.
Thank you, Mr. Chairman. Do you want comments on the second motion right now of selecting the control?
No, let's wait till we get to the second one. Yeah. So once again, since I opened it up again, public, if you have anything on rescinding the motion, that's what this is about. Okay. The chair would entertain a motion to rescind the motion adopted on August 6, 2019 Legislative Committee meeting relating to staff study and preparation of regulatory language to permit the C46 solar contractor classification to install battery energy storage systems on specified residential units with restrictions.
So moved.
I have a motion. Do I have a second?
Second, I guess.
I have a motion and a second. To the public, any questions? Board committee, questions? Felice, please.
Augie Beltran,
Aye.
Kevin Albanese, David De La Torre,
Nay.
Dave Diaz,
Aye, I guess.
motion passes.
All right, second part of this. Agenda item I. Review, discussion, and possible action to direct staff to identify and retain an outside consultant or expert to study energy storage systems, ESS, information received, and ESS installation issues, including safety concerns and appropriate contractor classifications to install ESS. As we previously explained in the last agenda item, there's a need to refer the study of this issue to a qualified expert to ensure that CSLB meets its mandate in ensuring public protection. Its mission of regulating the construction industry through policies that promote health, safety, and general welfare of the public in matters relating to construction, and that it complies with the law by supporting it with substantial evidence. The need for any proposed changes to regulations. That said, we already beat the horse in the last agenda item. Anybody have any comments? Now would be appropriate for your comment.
Oh, taking public?
Whatever the motion is, I want to make sure it includes risk, size, type, occupancy related to the ESS systems. And with all, like I said, basically the supporting documents, national codes and standards, national state codes and standards, excuse me, have some kind of threshold limits if that's necessary, but to at least look into that. and the economic impact analysis. Anyhow, that's what I got right now, so.
Any other board members have any specific comment to this issue? David? No? Counselor? Anything you want to say? This will be 5.
Well, I just want to make sure that the members understand that contracting process. We would send this matter out to bid if you authorize it, and the expert will determine how they want to conduct the study, but you will have a scope of work things that you want them to answer, and that will be included, and the staff will work with the Department of Consumer Affairs Contracts Unit and the Department of General Services to secure an expert who will study the issue. So I just want to make sure that that's
So to clarify, this fully formed motion will go to the big board,
correct.
and then the big board will be, at that time, will be made appraised of what you just said, because they're the ones who are actually going to make the motion to hire or to concur.
Right,
With this
to
fully
approve
formed
the
motion.
motion from the committee, if there is an approved motion.
Right. So if there are any board members out there, keep that in the back of your minds. So, public. I'll come back to you. Somebody killed me. Now, let's keep in mind that what we're going to speak to is not the how great C10s are and how great C46s are, exploding batteries and all that nonsense. We're going to speak specifically to what you want in the record and as far as if this motion is even made, because it hasn't been made yet. So, Mr. Bernanke.
Cut myself off here. Thank you, Mr. Chairman. Eddie Bernanke on behalf of the National Electrical Contractors Association. Again, I know this body is putting a lot of time into this issue, and we truly appreciate that. From the get-go, back in 2015 when we started this, it's been our opinion that the C46 license classification in its pure reading is not eligible to do this type of work, this battery energy storage work, under the way that their license definition is structured today. It's been determined by the board that they do this performance work under license under the incidental and supplemental provisions of the license law. I think in a recent opinion by the board to the city of Santa Clarita, it's been clarified that this is being performed by the C46s under the incidental and supplemental. So we would want to be sure that while we support the board, dotting their I's and crossing their T's and looking at this, that it's, kind of focused in on at what point is this work become no longer incidental and supplemental. The size, the scope, the energy output or storage of these, or ability to store of these systems, at what point is that no longer incidental and supplemental and becoming its own system? And so we think that's a big component and an important component of whatever study or comments that come back to the full board, and would hope that that would be part of the consultant's duties, is to have them look at what point do these systems no longer become incidental and supplemental. Thank you.
Thank you. Next.
Yeah, Mr. Chairman, Scott Wetcher on behalf of the California Coalition of Utility Employees and the State Association of Electrical Workers. First of all, I'd like to thank the staff and the board members and council for the patience and diligence and thoroughness in which you've conducted this entire process. And I'm so glad that you provided for the record today chronology of exactly how much work you all have put into this. Having said that, we have no problem supporting the idea of having a contracted individual expert do a study. I think that it's very important that they stay within the guideposts that Mr. Bernanke just outlined about exactly what the issue is relative to existing licensing law and that issue of supplemental and incidental. And secondly, I think that it's important that the scope be very clearly defined by this committee as to exactly what the expert's going to be looking at. And when it comes to the issue of economic analysis, where this is very common in other state agencies and within DCA, where you do an economic analysis of an impact of a particular regulation, but that needs to be based on verifiable governmental databases, not stuff that's pulled out of industry supplied information. I mean, it's got to be real verifiable data preferably, there's multiple databases within the state government that can provide that data. And so that's what we would ensure, that you need to be precise in the scope so that the public is aware, as well as the consultant, as to what exactly is going into this study. Thank you.
Thank you. Next.
Mr. Chairman, Richard Markison, today on behalf of the Plumbing, Heating, Cooling Contractors of California, the California chapters of the American Fire Sprinkler Association, and the Independent Roofing Contractors of California. The board recently took action to increase fees because of potential deficit in the board's budget. And so on behalf of the contractors that I represent that don't have a dog in this fight, I would say that there's going to be frustration and concern in as much as you've already spent 2 years of staff time that has not been calculated, but 2 years of staff time is a considerable investment. And now talking about hiring a consultant to come up with another report, essentially to justify some future action that the board may take. There will be frustration among the other license classifications, I think, when it becomes apparent that the board is spending who knows how much on an outside consultant to study this issue, particularly in light of the recent fee increases in the proposals to raise the statutory cap. So we would urge caution and certainly have an estimate for how much the consultant is going to cost, or possibly put a not to exceed cap on the proposal.
Thank you. Next.
Good morning, Brad Hebner with California Solar and Storage Association, CALSA. I was the primary author of the cost impact analysis that has been distributed here today under CALSA's name. With input from a lot of people, I reached out to a lot of contractors to get their input and thoughts on what the real impacts would be. Some of them thought what I put on paper was too low. I honestly tried to be middle ground on this. And yeah, as you see, it came up with an impact of $13 million in year one alone if you limit it to medium and large commercial only. And that is over $300 million between now and 2030. So those are real impacts. In my view, you don't need to spend a lot of money running likely to six figures on an independent consultant to tell you that there will be cost impacts. I think that the committee could hear a recommendation that there are zero cost impacts and find that not to be realistic without hiring an independent expert. With that said, we certainly would support further careful consideration of this. We're not at all opposed to the hiring of an independent expert. We pledge to work together collaboratively with that expert if you choose to go down that pathway. And I would just encourage you to do your best to find somebody who doesn't have preconceived opinions coming in. You want a person who doesn't have this thing all thought through in their minds coming in, but they can take evidence and trust a good researcher to find the best evidence from whatever sources he or she can find them to use their best judgment. Thank you.
Thank you. Anyone else?
Bernadette Del Chiara, Executive Director of the California Solar and Storage Association. I appreciate, and we want to be on the record of supporting the previous motion to rescind the August 6th decision, and we appreciate that. We also appreciate all the work the staff has put into this issue. We've been here since that February 23rd, 2018 initial meeting, and a lot of work has gone in to this. And over that period of time, not a single incident of harm or problem has been brought to your attention, despite the fact that the C46 licensed contractors have been installing hundreds and hundreds of solar and storage systems during that period of time. I want to just remind the board that the events of the past 3 weeks alone should give you enough pause to just put this issue to rest and not spend any more tax dollars on studying the issue. We've got elderly citizens needing energy, electricity, reliable supplies of electricity for their homes. We've got people with medical needs fully dependent on a reliable supply of electricity. the events of the past few weeks make this whole restriction of trade, increasing the cost of the one solution that is going to be able to come to the rescue for California consumers, it needs to just be taken off the table completely. Thank you.
Anyone else?
Yes, good morning, ladies and gentlemen of the board. Thank you for your time. My name is Julius Cherry. I'm the retired fire chief from the city of Sacramento, where I worked for more than 30 years. And in that capacity, I was a long-term member, even in post-retirement, of the International Association of Fire Chiefs, as well as NFPA. I'd like to associate myself with the comments that Commissioner Diaz made when he said training is huge, because that's absolutely true. Energy storage systems improperly installed do have a serious risk of fire, electrical shock, flash burns, explosions, and exposure to hazardous materials. Well, first of all, I should say at the onset, we support the motion to have an independent consultant come in and study the issue. And in that vein, I think a very serious focus on NFPA 855 that is really the Bible, so to speak, on energy storage systems. As I understand it, at some previous hearing, someone who purported to be a member of the fire service got up and said that as long as the system had a UL approval, that it was safe, regardless of whether or not it was improperly stored or improperly maintained. With all due respect to whoever said that, it's nonsense. Just because something has a underwriter's lab approval doesn't mean if the product is misused, improperly installed, or improperly maintained, that it doesn't pose the risk that I talked about a few minutes ago. I think the idea that the committee would consider a size threshold for energy storage system above which it is not treated as simply supplemental to PVC is where ultimately this should end up. And again, we support the motion and strongly urge whoever you end up hiring to focus and bring you back information on the validity of NFPA 855. Thank you.
Thank you. Anyone else?
Tom Enslow, attorney for the IBW NICA LMCC. Just a couple points in what's being proposed. First of all, if there's a study that goes forward, any economic analysis really needs to be based on what the existing regulatory baseline is, which is currently, and the existing, how this actually works, right now in the world. The existing baseline is that C46 contractors are authorized to do PV installations. It's silent. The regulation is silent as to energy storage system. Is a dispute that we guys are trying to resolve as to whether or not energy storage systems can be incidental and supplemental work. And what the full board has asked is there a threshold at one point where, we need to, this should not fall into the C46 this should not fall under the C46 license. And this is based, largely on the fact that the larger these energy storage systems are, the more dangerous they are. And when we do this report, I urge that we don't reinvent the wheel. We look at the industry standards and codes that are out there, and they all uniformly set size thresholds above which they require installers and permitting to take extra precautions because these become more dangerous. And this is, what should be looked at here is, if there's thresholds, what should be asked is that what are the potential thresholds? And that should be brought to the board by the expert, and the experts say these are the thresholds you could use based on this evidence, and it's up to the board to decide which ones they should choose. But the board needs to know what are the thresholds that are already being used out there as far as size, where we take extra precaution, and then determine whether any of that makes sense if they want to take the existing regulations and clarify what is incidental and supplemental work and what's not. The other point I'd like to quickly make is just the economic analysis baseline, and also has to be based on the fact that right now not every energy storage system is being installed by C46 contractor. The larger ones are generally being installed by C10 contractors. 40% of C46 contractors already have C10 contractor license, so they won't be affected by this. So you're only talking a few hundred contractors that would actually even be affected by this regulation. the most of the industry right now that are doing larger systems have C10 licenses. And so they, already would meet this requirement. They already have that extra level of precaution to make sure that when they do energy storage, they do it right. And they're also allowed to do it independently as well. So they have that expertise. Thank you.
Thank you. Anyone else? Bringing it back to the board. Oh, all right.
In the name of economic reporting on this, I'd be very curious to see another side, if it can be afforded and if it could be, the time could be felled, about the economic impact of the ongoing indecision that we've had. Because someone used the phrase earlier, beating a dead horse on this issue, and it's been going on for a number of years. And the fallout that I've seen from that, as someone who works in the solar industry, someone who also works in the electrical contracting industry, is that it's kind of giving solar energy storage and kind of the new age of electrical contracting, as I call it, as we continue to push towards renewables, a black eye. Because I've been seeing the numerous articles about this internal struggle that's going on in our community. I've been seeing ongoing things where people are saying, well, I want to pick the right people. The mention about having 3 different people in different shirts, each doing a different part, certainly isn't a good look. So I'd be curious to see in that economic impact what the damage has been for not, moving forward with that, and what will go on if we don't actually come to a decision soon. And on that note, I like to look at facts as well. And the one thing I've, just factually speaking, there are over 33,000 C10 contractors. I've made this point before, I think in San Diego about a year ago. And there are about 900 or so C46 contractors, over 40% of which also have a C10. So the number of contractors we're actually speaking about here, putting regulation on, is about 500. So I just want that to sink in for a second. And finally, I did an independent report that I didn't release, but I was commissioned by NEEC and IBW to do this, that looked at both C46 contractors and C10 contractors to see code violations and issues. And big surprise, both have code violations. I have on my laptop right now a report that has the screenshots, the photocopies of C46 contractors who operated, who did installs and had fires, who had explosions. And there was one in Marietta, California. They didn't even pull a permit, a solar C46 contractor. Went to dig, which was something that we were talking about earlier in this meeting, went to dig to do the grounding and actually hit a line and it exploded and killed someone. So, I mean, there are real issues here. And on the same side, C10 contractors had various code things as well. It just comes with the territory. There's always going to be people who don't do this stuff well. So I'd like to see the economic development. I'd like to make sure this is resolved soon. And yes, safety is the number one priority in this, because not only do we want people to be doing this safe, we want things to not be burning down, but we want to continue moving towards global warming abatement. And that's very important that we get this figured out and we get it figured out properly. Thank you.
Go ahead.
Thank you. Good morning. My name is Ed Murray. I'm with Aztec Solar, a couple of exits up the road in Rancho Cordova, and I'm also the president of the California Solar and Storage Association. Just to rebut what was just said, the contractor in Marietta was a B contractor, not a C46 contractor. I want everybody to know that. So it wasn't a C46. I've been a C46 since 1980, and we've been installing storage. We have a container of storage systems in our warehouse right now because of all the fires that we have out there, and we're installing them safely every day. I'm also a B contractor, but I can tell you that there's not an issue with safety, and I appreciate the board for putting out this. Thank you.
Duly noted. Thank you, sir. Anyone else? Okay, coming back to the board. So,
Yeah, well,
go ahead, David.
I just want to make sure, when we do, I know you want to make a motion or have somebody make a motion or whatever it is.
Nope, we can talk about this as long as we have to.
No,
It's
I'm not talking about that.
important for
I want
everybody to get their point
across.
across.
Yeah, I just want to make sure that, I'd like to see a couple board members, I don't even care who it is, that, or committee members that are on this, because I want to make sure that the scope of whatever we do with the outside consultant, make sure that we add all this stuff in, or the way staff will direct it, or whatever it is, so.
If I may.
Oh, okay.
If you may.
I would recommend that the board members and committee members stay separate from the expert selection process. I would highly recommend that we move forward with the staff working with the control agencies to develop this information. They may need to consult with other experts on scope, but in order to make sure that when you make a decision, that we have what I consider an independent report, fully independent report, and there is no perception of any kind of influence or bias to the expert, I would recommend that it just be left to the expert to determine what information they need to meet the scope of work that the staff work with the control agencies to develop. That's typically how we select experts. We usually don't have the board members involved in that process.
No, I wasn't talking about board members being in the process of selecting the outside consultant. I was talking just about the scope of where you wanted to go.
Well, I think staff has taken pretty good notes today.
Okay.
They've
But
noted.
is it going to be in the motion, though?
No. They've noted concerns. They've noted the public's concerns. And when they come to the big board, if this motion were to go through and pass, Counselor's exactly right. That's why staff is here to support us by taking notes and listening to us, listening to the public. And when we put out the RFP, when staff puts out the RFP for the consultant, whoever that person may be, or persons, they will note our concerns, the public concerns, and I am sure that this consultant will take all the evidence that's been provided from today going back to the beginning of time. And I'm sure the way consultants work, they're also going to take new testimony. So, but that's not, I mean, that's why we're getting that person, so we have an arm's length from this very emotional journey, and that we can make a fair and impartial decision. Yes, Kevin.
Yeah, no, I agree that we should move forward with an independent. I share the frustration, I think, that I'm hearing from the public. We've been talking about this since 2015 or so. The amount of time that we've spent on this issue has been inordinate compared to everything else that we've dealt with. There's three branches of government. You got the legislative, you got the executive, you got the judiciary. We're talking about statutes, interpreting statutes. I think we've provided our interpretation of what the C-46 regulation is. You know, that's, if we're wrong, that's through the judiciary. You know, if this is a political question, that's more for the legislature. We are not a political body. We're an executive body. And what we need is we need evidence showing the harm that we're going to fix by enacting this regulation. Either, and that may be existing harm or that may be prospective harm, you know, that whatever that is. And so I think, you know, we need to move with some dispatch on this, get it right, and either put it to bed or take action sooner rather than later. And what I would suggest as part of the motion is that at the next board meeting, staff come up with what the statement of work looks like. You know, what are...
Which board meeting? The big one or the little one?
The big one.
Okay.
With the
It takes a really long time to work through the process, and we don't have control over that. A lot of it has to do with working with the Department of General Services, and so I would suggest that we allow staff to do that work and provide that information. If you want to provide input on the scope of work, that's fine. But as far as the board approving the scope of work, I would be concerned about that because it still has to go through the other control agencies to be approved. And
All right.
and I don't know that we want to hold it back.
Fair enough.
that would be my
I guess
concern.
the point is if there could be some sort of guidance perhaps that's brought back with, you know, with the motion or the recommendation to the board. You know, these are
Just
the.
general areas that have
just
been
general
raised
areas,
over the
you know,
course of the meetings.
Evidence of harm, you know, is it current harm?
Safety
Is it
issues,
prospective? You know, what are,
economic.
exactly. And in
Sure.
a real factual, objective manner. And then we put a timeline on it, just so that we do get get the certainty that the C-46 and the C-10 deserve, that our consumers deserve, that all of our people deserve.
David, you want something else to say?
I'm just, so the board can't, and no board member should comment or say anything about the scope of what this should be? Is that what you're saying?
That we already have. So just in this meeting alone, they've noted, everyone who's spoken, they've noted their concerns. I see their pens busily, mightily writing here. So it's also, the public record is also public, it's on camera. So they're gonna review what's been said today to make sure that everything that's been said is incorporated. And the registrar, through his department, working with legal, is going to put out an RFP, I'm assuming, and they're gonna know what they need. They know the parameters that they need to find out, to give us what we need to make an appropriate decision. So based on what they've heard today, heard in the past, David being the registrar, they know what we need in order to make a good decision. And they will impart that to whoever they hire.
Yeah, I get it. I understand, but also the original motion that happened in August was mine, and I thought it was all a done deal that we were going to go forward on it, so things do change, so that's all I'm saying.
That's true.
So,
Okay. Duly noted. So at this time, the chair would accept a motion to send to the big board to retain an outside consultant or experts or consultants to consider energy storage system information received, perform additional fact-finding as necessary, and provide analysis regarding ESS installation issues, including timely concerns, and the appropriate contractor license classification or classifications to install the battery energy systems. And I think I heard something about a timeline. Can you guys do that at the next meeting, David?
Yes, we can.
Okay, chair would accept that motion.
So moved.
Chair has a motion. Is there a second?
Second.
There's a motion and a second. Public, do you have any questions on the motion?
Mr. Chairman, board members, Eddie Bernacchi on behalf of NECA. Just one point of clarification. The staff is going to bring a scope, out of this motion, a scope for retaining a consultant, and within that direction of retaining the consultant, there will be a scope of what they're to look at. Is that what we're hearing?
We're not going to have the scope of work. We're not going to have that done by December. It has to go through many channels before it's approved. What we're going to have are the concepts or issues that have been raised by various stakeholders that have been brought up during the course of all these meetings that we're going to be generally disclosing to the board. So those are the areas that the expert would be studying, but we're not going to have the actual scope of work done
Okay, hold on.
by the
Christie,
December
hold on.
meeting. Yes.
David, registrar, could you answer the questions going forward?
Yes, what the plan would be is to bring back to the board at the December 12th meeting the general areas that we would be looking to put out to bid, and also the timeline that will generally, what it will generally take to accomplish the study, and also the regulatory process should the board want to go that direction.
Okay. Can I add on to my comment? Then the current position of the board is that the C46 licensee can perform this work when installing, at the same time they're installing a photovoltaic system.
So
Correct.
that is not pertinent to the motion.
Well, it's more a public comment just in general. Will the board be providing broad declaration to some of the comments today that there's confusion in the industry? So would like an industry bulletin be issued? Or could that happen?
That could be on a future agenda item.
Well, hold on, because what I will do at the end of at the end of this, I will open up for general public comment for anyone who wants to talk on
thank you.
any matter.
Mr. Chairman and members, Scott Wetch again on the State Association of Electrical Workers, California Coalition of Utility Employees. I very much appreciate the registrar's clarifications. I have to, with all due respect, categorically disagree with the council's suggestion to the public members of this committee that somehow it's appropriate for the board to authorize this expenditure of a study without giving the scope. There's a difference between specs in an RFP and scope. in all good conscience, you should not be able to vote to spend money on this study if it's not very clear as to what the scope of that study is going to be. We see it across state government every day. Over 30 years of practicing state government, I've never seen a board or commission adopt a study without being specific to what the scope's going to be. That's not going through the Department of General Services spec process of putting together an RFP that meets all the requirements of the public contract code and the government code. That's a separate process. You most certainly need to understand what the scope is, and I think what Register Folk did was differentiate between spec and scope. And we would then continue to support the idea of a study being approved if, as described by the Register, the board was going to be given, the broad sort of scoping of what that study is going to entail. Thank you.
Thank you. Next.
Brad Hebner with CALSA. Having hired researchers a lot for research projects, I think we have a definitional issue here. Scope of work tends to be, it's a contractual thing. It often isn't done when you have selected the researcher. You go back and forth on the very detailed scope that's part of the contract for the work. That's not what we want to do at this level. I fully support what you seem to be indicating your intention is, to give a general guideline, to give an outline and direction as to what it is to be studied. But careful not to call it the scope of work.
Thank you. Anyone else?
Yeah, Tom Enslow. I just want to reiterate what Scott Wedge says. I have never seen a scope of work approved by a board, a study approved by a board without the scope being set. This is just going to create what you guys just did for the last 2 years, is it's going to be back and forth. There's going to be an undefined scope of what someone's going to study. At this point, there's been 2 years of testimony. The board should be able to narrow down the questions that it has and then look to the expert to provide that information. And I'll say that, you already heard, contractors, you already heard the PHCC complain about the money being spent unwisely in this process. Nothing would be more unwise than to move forward with a study without a defined scope. At this point, you guys should have specific questions that can be answered, specific information that you're asking for, and a expert should be able to provide you that. To just have a wide open question, we're not going to be moving forward, and it would be a waste of money.
Thank you. Anyone else? Coming back to the board. There's a motion and a second. Yes.
Do we have to worry about how much it's going to cost?
Absolutely.
So how do we know that?
We'll figure it out when we get there. That's what staff, that's their next charge.
So we could take it out to bid and then come back?
I don't know. Staff has got to sit down.
You got to have some kind of approval with the money.
David, can you answer
right?
the question?
Yes. What the plan would be, I just going to reiterate, we would come to the board on December 12th with the general areas we want to look at. And we've been studying this now for almost 2 years. So we really do have an understanding of what areas need to be looked at and where I think we can really help to bring some clarity. As far as the cost, we're fortunate to have Tanya Corcoran as the Chief Deputy Registrar here, and she has a lot of experience with these type of contracts and what the cost would be. What we haven't done yet, because we're waiting for approval from the committee and from the board, is to determine what the average cost would be for a study such as this, for this type of work. And this isn't the first time it's been done. We can reach out to our partnering board and bureaus that have done similar, have hired similar consultants to find out what they've paid. And we'll be prepared to bring that back to the full board on December 12th to give you an idea as to what this will cost.
Anything else from the board? No? David? Anything?
We were talking about, well, some of the speakers were talking about scope. Isn't the scope the energy, the ESS?
David?
That's the scope, right?
Registrar David, answer that, please.
Yeah, we've heard a lot today about what the larger issues are here. One is the economics of this. We've got difference of opinion, so certainly it would be helpful to take a look at that. We know we need to look at safety issues. This all relates to the battery energy storage system matter. That is the overall scope of what we'd be looking at. It's a general scope. But we also have heard that we should take a look at code requirements and size and complexity of these systems. It's nothing that we haven't been hearing about from the last 2 years. Those are the general areas that we need to have an independent party look at and then provide recommendations and bring those back to the board.
Anything else from the board? Felice, please take roll. Yeah, motion was made of Kevin and second of David.
Augie Beltran,
Aye.
Kevin Albanese,
Aye.
David De La Torre,
Aye.
Dave Diaz.
Aye.
Motion passes.
Thank you. With that, I'm going to open up public comment once again. If you guys want to get up and say whatever you want, I don't care if you want to say, wash my car.
Definitely could use the car wash on.
Mine
Point of
could,
order,
yeah,
though,
it
3
hasn't
minutes,
rained in a
right?
while.
Eddie Bernacchi on behalf of National Electrical Contractors Association, one more time. I think that when this started in 2015, there has been quite a bit of confusion on what the board's current position is on when a C46 contractor is authorized to install these battery energy storage systems, when they may need an additional license, the C10 license or the A and B. I think it'd behoove the board and the industry in total if, and I know you've done this in the past, if an industry bulletin could be issued to agencies and contractors on the proper classification now, as the board has determined it for the last 15 years, now to install these systems so that everyone knows the playing field we're dealing with. This process has muddied the waters even more, and there is quite a bit of confusion out there in the industry on what license classification they need in what circumstances. So I would encourage the board to move forward on a bulletin.
Thank you for your thoughts. Does anybody else? Yes.
Mr. Chairman and members, Richard Markson, now on behalf of the Western Electrical Contractors Association. A couple of speakers brought up the question of electrician certification, something that WECA for a long time has supported, and it points out, we believe, that the current inconsistency in the electrician certification law that only applies to a C10 contractor. We believe that covered electrical work, irrespective of who the employer or contractor is, should be done by a certified electrician. If it's a swimming pool contractor and they're installing the energy for swimming pool motors and lighting, that should be done by a certified electrician. If it's a C46 that's doing energy storage system, that should be done by a certified electrician. That's a long-held belief. Unfortunately, we have been unsuccessful in expanding beyond the current requirement for C10, but ultimately we think that that would resolve a lot of the questions about safety, qualifications, and the preparation to do that kind
Thank you,
of
sir.
work.
I was pleased, I think if I heard Mr. Bernanke correctly, that the request for a bulletin go out to clarify that the C46 contractors under current regulation are allowed to do solar and storage concurrently today, as they have actually for 40 years. Glad to hear that recognition of that fact. We would support that being clarified. There is a lot of disruption and confusion in the industry and in the market right now. I also want to remind this board of the existing problem that has been in place and has been a thorn in our side since December of 2018, and that is around the issue of modifying an existing PV system with an energy storage device. We contend that that is something the C46 has always done, that this licensing board has always allowed, and to restrict the C46 contractors on those terms is already causing significant damage to the market. I get phone calls and emails from my member companies that are C46 whose phones are ringing off the hook right now from their previous solar consumers, their customers, that they went and installed a solar system on their home. They'd like to add a battery in light of the fires and the PSPS events so they can keep the lights on when the blackouts happen. My contractors that are C46, and also I'll remind you A and B, are now not able to go and service their customers to add a battery, modifying their system with a battery. I'll remind you that there's a serious consumer protection issue that this triggers. In my contractors' contracts, they warranty their work unless another contractor comes in and touches the system that voids the warranty. So you're putting the consumer in a really tough spot. They either are voiding the warranty on their existing PV system, and getting a battery, or they're foregoing the ability to have reliable self-generation power during the next blackout. This is causing serious problems right now in the interpretation of this decision by your enforcement officer here at the CSLB. The SCHIP program, the rebate program administered by the 3 investor-owned utilities in the state of California, providing rebates for consumers to go solar and add a battery to their solar system, actually specifies that only a C10 can do a retrofit work per this agency's decision through one enforcement officer. That means that my Bs, my As, and my C46s are right now unable to do that work and receive a rebate on behalf of their customer. This is a huge problem. We've been wanting to sit down with the enforcement officer and with the staff of the CSLB and really discuss this issue and get to the bottom of it. We have the ability as a C46 to modify a PV system. The PV system has always been inclusive of energy storage for 40 years.
Thank you for your thoughts.
Thank you.
Anyone else? Here's your last opportunity. With that, that's closed. Chair would entertain a motion to adjourn. Motion is second to adjourn. Feliz, please.
Augie Beltran,
Aye.
Kevin Albanese. David De La Torre. Dave Diaz.
Yep.
We're adjourned.
Really?